So I would like to open the first session that is discussing consumer protection policies and the debates that are surrounding now how the consumer protection legislation, in terms of policy coherence, should change. So at this particular moment, I would like to welcome the first speaker, maybe to present herself, themselves a little bit, and start with the presentation. Do we have the first speaker present?
Yeah.
Perfect. So Alessio, if you want to say a little bit about yourself, where do you come from? I prefer you putting the background than me.
Thank you very much,
You're
Leila,
very welcome.
and thank you very much for having me here. My name is Alessio Bartolacelli. I'm an associate professor of company law and business law and European business law at the University of Macerata in Italy and at the Riga Graduate School of Law in Riga, Latvia. And I am the chair, the Jean Monnet Chair Business Law in the European Union and Sustainable Economy that is active since last year at the University of Macerata. My presentation today is dealing with consumer protection as a driver for a more sustainable corporate governance. And I hope that I can share my screen now. So please, Leila, let me know if it works. I really very much hope so.
Works beautifully, thank you.
Perfect, thank you very much. So, using consumer protection for a more suitable corporate governance, and my point of view is the point of view of an Italian legal scholar, and I am going to deal in particular with Italian law in this field, but there are possible fallouts at European-wide level as well. So benefit companies, social enterprises, third sector organizations, there are forms that we are going to see that are present in Italian law, evidence from Italian business law. The key question of my intervention is this: how can we enforce companies that have a theoretical, at least theoretical social purpose to actually walk the talk, to actually make what they told that they were committed to in sustainable terms? But the preliminary question that we must pose is this: which kind of companies are we talking about and where? Well, I am going to talk about social enterprises, other social organizations, benefit companies. I know that you have had a talk about that, an extensive talk about that in your first edition of this conference last year. But I'd like to point out how what I'm going to say can be useful also for common companies, somehow common companies. And as for the where, in Italy, but also with a few remarks applicable at least Europe-wide, and perhaps even at a broader extent. Unfair competition in Italy, just an overview, a very quick overview. The key provisions are contained in Civil Code and the Consumers Code. We have a basic distinction between specific practices that are confusion, imitation, denigration, misappropriation of the qualities of other entrepreneurs, but I think that this is rather common almost everywhere. But we have also a general clause that is commits an Unfair Competition Act whoever uses in a direct or indirect way any other instrument that is not appropriate to the principles of business loyalty and suitable to create a prejudice to another enterprise. So we are here in a situation of market competition, basically. But we have also the provision dealing with unfair commercial practices that are contained basically in the article 18 to 27 of the Consumers Code, of the Italian Consumers Code, and they are an act, omission, conduct, or statement, commercial communication, including advertising or marketing of the product by a professional, by an enterprise, in connection with promotion, sale, or supply or product to consumers, which is contrary to professional diligence. It is false or likely to distort to an appreciable extent the economic behavior of a consumer or of a group of consumers. So, can they distort their behavior? The consumer would have purchased the same good from another entrepreneur if they had known that the company or the firm that does not actually purchase the sustainable attitude that is advertised is not actually pursued? This is the big question. Is this interesting for our purposes? Definitely, yes. There is a competition between the common and the sustainable operators within the same market. The sustainable economic operator satisfies at once both the markets and the connective needs, but this has different degrees in which this can happen, because there is not a general approach or a one-size-fits-all approach. The measure of of the commitment is dependent on the member's decision, is dependent basically on the owner's decision, and this perhaps can be also referred to some kind of a shareholder's primacy. But we have always the need to understand if and how shareholders have the power to enforce the director's approach to the business. This is a key issue. It is not the topic of today's intervention, and so I'm not going further in this direction, but this is a key issue to be always reminded. The operator, on the other hand, needs to signal to the market the fact that it is sustainable, or it wants to pursue a sustainable attitude. And here we need to verify whether such a declared approach or attitude is actually performed by the operator. So, what enterprises are we talking about? I told you, social business organization. That are the social enterprises, properly speaking, that have been introduced in Italian law in 2000, as of 2006, but also refurbished or rephrased in 2017 with a major reform of the so-called third sector. The third sector organizations that are no-profit organizations that have been unified in 2017 within that reform that I was talking about, and they are meaningful to our purposes when they are carrying out economic activity that is not necessary given, because they could even have a purely social approach and a selfless approach, so they could even not be enterprises, properly speaking. But we can also talk about common business organizations that have a sustainable approach as well. And from this point of view, we have, since 2016 in Italy, benefit companies that were born in the United States and that have now reached Europe more recently, the so-called società benefit in Italian law. They have been introduced at the end of 2015 and they are in force since the beginning of 2016. What is their specificity? The directors should pursue the economic activity and the profit purpose along with or together with or balancing it with a common good purpose to be decided by the shareholders. Other companies, those companies that don't have the qualification of società benefit, are they entitled to pursue economic activity? Well, a common good activity? Well, this is a rather questionable under Italian law. Currently, the most shared idea is the fact that we must make a distinction between a common good purpose and common good activities. Perhaps it cannot pursue common good purpose, but it can make common good activities. Let's start with the social business organizations. There were major innovations as of July 2017. Third sector organizations that are no-profit purposes, social enterprises that have been modified, amended in 2017 by putting something that is very interesting, that is that until 2017, they were forbidden from distributing profits between the shareholders, their members, but since 2017, they can distribute low profit. They are low profit organizations, and they are also ex lege by a specific provision third sector organizations as well. They have as a main characteristic, as a main feature, the fact that they must pursue civic, solidaristic, and social utility purpose by means of activities of general interest. And such activities could be also carried out by general companies or firms, naturally, so there is not an exclusivity of that but by the social enterprises or the third sector organizations. Basically, they are enjoying tax law benefits, tax law reliefs, and naturally, the social recognition of their commitment. And the social recognition is made by means of two specific labels. These organizations must include in their name the fact that they are social enterprises or third sector organizations. They must use the label. There is no choice. And it is rather interesting and I think rather reasonable because by this way they are giving a signal to the market saying, okay, I am not pursuing a profit purpose or I am pursuing just a very low profit purpose. What happens if they don't walk the talk? Well, in this case, naturally, the unfair competition remedies are naturally applicable and so are enforceable by the consumers and by the competitors. And if they are recognized as not pursuing actually the declared purpose, social purpose, they are going to be disqualified as third sector organizations or social enterprises, but they still remain business organizations. They are simply disqualified from that qualification, but they are still business organizations. With benefit companies, the things are rather different because the basic notion in Italian law for general companies is the fact that the company or the partnership purpose is to distribute the generated profits among its members. This is a provision coming from the Italian company law, civil code as well. This means, okay, which kind of profit? The profits can be made with a short-term perspective, naturally, but they could also come with a longer-term perspective if this is economically profitable for the company. This is the most shared opinion by the Italian scholars in the field, probably even just as far as the reputation is concerned. In general, this applies to any company or partnerships, but since 2016, we have this new form or label of the benefit companies that is not specifically a company form, but basically just a label that can be put on any company form when they have in their article of association the fact that the directors must pursue in a common good purpose along with or balancing it with a profit purpose. So they are compatible with all the existing partnership company and even cooperative forms. And there is this duty, the specific duty to pursue the common good balanced with the profit, the profit purpose by the directors. So the profit purpose, even benefit companies must be present, but it must be balanced with the common good purpose. And what about the other companies? Well, according to Italian law, partnership and companies that are not società benefit, if they also intend to pursue common benefit purposes, must modify their articles of association. And in my opinion, if they modify their articles of association, they become benefit companies. Because the fact that there is this mention in the articles of association by itself is sufficient for having this company defined specifically as a benefit company. So this means that the società benefit only are entitled to pursue common benefit purposes, and the other common companies could carry out activities, but not purposes. And it is very much borderline, naturally. And even more, the most dangerous thing is that this happens without a specific penalty. But what's interesting here is this. While for the social enterprises and the third sector organizations, we have the need that these organizations have their label, società, organizzazione del terzo settore, or impresa sociale. In this case, we don't have this need. This is the possibility for the company to include this name, this denomination in its name, but there is no duty to do that. And this creates some kind of problem. Because in this sense, we could have benefit companies that are not advertising themselves as benefit companies. Naturally, it is usual that the majority of benefit companies are advertising as benefit companies. But we could also have some kind of, well, opportunistic behaviors. That is, well, I'm not that sure if I'm going to pursue the common good activity. I'm putting it in the Articles of Association, so I am a benefit company, but I'm not advertising it, just to avoid so many problems if I'm failing in working the talk. So from this point of view, this is extremely interesting. Also from the consumers protection point of view. Besides that, how can we be sure that the società benefit, irrespective of its actual denomination, is actually working the talk? From my point of view, the biggest problem is the fact that there is not a minimum threshold of benefit purpose to be pursued by the company, and the scientific assessment of the actual purpose of this common good purpose only is made ex post, and so by means of a report. But if the minimum is really a minimum, we have a substantive problem that leads us again to this, to the fact that we don't have a minimum threshold. So the choice of being a benefit company could be simply driven by a reputational advantages, with no need for an effective common benefit purpose to be pursued. So two best questions. What if the società benefit does not pursue any common benefit purpose, on the one hand? That is the biggest problem. And second, what if the società benefit actually pursues just minimal common benefit purposes? Are there limits to hinder such a practice? Is my question. Well, a brief answer to question one. Company profiles, we have a director's liability. It is not something that interests us particularly today. It is debatable whether it is actually enforceable under Italian law, because there are some entrances by the Italian legislation for that, and for sure the shareholders can do that if the directors are failing in this. But if the directors are making very much money with the company, the shareholders don't have a real interest in enforcing it with their directors. And we have the problem that the other stakeholders probably don't have any kind of remedy. There is a debate currently in Italy, but the majority of the scholars agree that they cannot enforce it directly with the directors. But we have also the competition law that is much more interesting to us today, the competition law profile, because here we are facing an unfair commercial practice, and there is a misleading advertisement, because the company has declared that it has a common benefit purpose that is not actually pursued. And Italian law explicitly refers to this in the società benefit rules. So the issue is very relevant. There was no need for a specific mention of the application of the rule. And the question is why the Italian lawmaker decided to put this specific remark in the legislation, because the legislation naturally was applicable to the società benefit as it is applicable to any other company form or enterprise form. It would have been reasonably held as applicable in any case to società benefit that are advertised as società benefit, but in my opinion, the fact that this has been explicitly stated by the law means that this unfair competition remedy is applicable also to those società benefit that did not advertise themselves legitimately, did not advertise themselves as società benefit. Without a specific reference, perhaps it was not possible to apply this rule, because there was not an advertisement, properly speaking. There was simply a mention within the Articles of Association, but the Articles of Association are not reliable against the third parties, usually, according to Italian law. And even more, it is to be held as an advertisement, even if the common consumer does not usually check the trade register. That is the only place where the Articles of Association could be checked by the consumers. And the consumers, all of us know that the consumers usually don't go to the trade register to have this, to get such kind of information. Let's move to the question 2 very quickly. Just minimal benefit purpose. Is it possible? Well, Italian law on società benefit is silent on that. But we have in this case too some rules on misleading commercial practices that seems to me very useful, because the practice that even if the information is factually correct, so even if the company actually possesses a minimum of a common benefit, it nevertheless causes or is likely to cause the consumer to take a decision that he would not have taken based on the extent of the trader's commitment. And I think that this is the very point. If the extent of the trader's commitment is very low, at that point, this could be enforceable. And who is entitled at this point to force the company to change its attitude and to enlarge its scope of benefit purpose? Well, this solution would give the antitrust, or better, the national authorities that are given the power to enforce these rules according to each national law, the possibility to enforce it. The competent authority for deciding on this claim would be the administrative or judicial body with a competence over unfair commercial practices. In Italy, l'Autorità Indipendente per la Concorrenza e il Mercato, that's the Italian antitrust agency. Such a conclusion seems to be extremely useful, because a specialized authority, a public authority, would take care of these issues too. And it could serve as a sort of qualified gatekeeper, I call it here, also with reference to the minimum quantity of common benefit purposes that is to be carried out by a company for being actually a società benefit, even if it does not advertise itself as a società company. Very briefly, so that I can close, what about the non-benefit companies? Well, in this case, we don't have the purpose, as I told you before, but we have the activity only. How the commitment of carrying out this social benefit activity has been advertised, perhaps not via the articles, because if it is on the articles, it could become a società benefit. But here it depends. I already told you that it depends if it is a purpose or an activity. It's rather borderline. But even if they are in the articles, even the case, it's debatable whether third parties can rely on the articles without a specific enabling rule for the reasons that I already told you before. And without a means of disclosure, naturally, if it happens without a means of disclosure, this is an advertisement. And if this is an advertisement, the usual unfair competition rules are applicable. So, therefore, the national competent authorities would perfectly serve to set the appropriate and consistent thresholds in this case too. In any case, in this case, I don't see any specific remedy at the company law level as applicable. So far, with reference to Italy. But, and outside Italy, well, the competition law remedies that we have observed so far, all of them are coming from the European Union law. And in particular, we have to reference the Directive 2005-29, with its later amendments of the European Parliament and Council on unfair business to consumer commercial practices, in the particular the Article 6 on misleading actions. These provisions are exactly the same that I've already told you about with reference to Italian law. So the national competent courts or administrative authorities are completely entitled to serve as gatekeepers of the effectiveness of the common benefit. And this would facilitate the possibility for a sort of bottom-up harmonization if there is some kind of agreement or common approach or common attitude by the national authorities in this field. Pursuant to the specific features proper to each national experience, naturally, because we have each member state has its own national experiences and its own approaches to this, but there is this possibility, and I think that it is a possibility that is very much worth considering for having a common benefit enterprises approach at European level. Thank you very much for your attention, and please feel free to ask me your questions, if any.
Thank you very much, Alessio. This was extremely interesting. Before I start posing questions and putting comments, please, for our audience, if you have a question, if you have a remark, if you want to discuss it further, you can put on your microphone and your camera and start speaking. Or if you prefer, you can put your question in the chat, and we will try to answer it.
Leila,
yes.
Sorry, can you stop by the screening? I'm not that sure. Okay, yeah, thank you.
Okay, I almost did it. I almost did it instead of you, so don't worry. No worries. Okay. If there are no questions for the second, then I will start. Thank you very much for the presentation. This was extremely interesting because, once again, it shows what I've been claiming the whole time, and not just me. There are many scholars out there who are claiming we don't need new tools. We need some of them, and we need the revision of corporate law per se. But to start the journey of corporate sustainability, we definitely don't need new rules. Second thing that I just wanted to note before I put the word forward to another participant is the issue that you noted here that quite recently many scholars didn't think about yet, but started more and more of saying, do we really need a special form of a corporation to say you need to be responsible?
Right.
So that is kind of counterproductive because you are allowing by that for the others to be irresponsible. So it doesn't work. Like, instead of helping, it sometimes disincentivizes action on the matter because it's like, okay, so if I'm regular, I'm supposed to be negative. So those are kind of my challenges. So I've seen a participant questions.
If anyone else wants to pop in and jump in, please feel free. But may I just share your idea? I mean, I wrote this a couple of years ago. I think that it is counterproductive, absolutely counterproductive. Absolutely counterproductive. And if you read the Italian version of the società benefit rules, are very nice because the starting of it all says benefit companies must have a sustainable, transparent, and common benefit attitude. That means that the non-società benefit, the other companies, must be not transparent, not sustainable.
Exactly.
And this is really astonishing because it is the signal of an idea that is actually to be changed. And I very much I'm in accord with you when you say that well, we have the tools, but what we should change is the mind that we have in using the tools.
Yes, that's for sure. If you take it 2 steps furthermore, you can even say, okay, so now ensuring profit for the shareholders and for longevity or the survival of the company, you are supposed to have negative externalities in terms of environmental and social sustainability. Otherwise, you're not profitable, which has been disproven by scholarship. So that kind of worries me because it's like we're using things that have not been proven by scholarship lately. We really don't have any questions, any doubts. That surprises me. Nobody in the audience wants to comment anything or ask anything. We are not going to have Alessio for long here. We have him for 3 minutes more. So either it's now or never. No? Okay. Maybe we come back with some comments later on at the end of the session, and we can maybe give the word to Laura Best and Miemie. Thank you very much, Alessio. That was really enjoyable.
Thank you very much once again. Bye.
Laura, very welcome.
Yes.
You're
Thank
ready?
you. Yes, I'm ready. Thank you very much for this invitation. I'm here together with my colleague, Miemie
Miemie,
Struwig.
exactly.
But we decided that if it's okay, I will do the presentation. But when it comes to discussions, of course, Miemie will join me.
Not a problem at all.
Thank you. So just to, you asked us to say a few words about ourselves. I will do that.
Please do so. Thank you.
Yes. So we are both based at Nelson Mandela University in Port Elizabeth in South Africa, and in the management sciences domain. What I also do in another part of my life is I serve as the Deputy Chairperson of the National Consumer Tribunal, which is the tribunal that adjudicates on consumer protection. So that is some of the focus that I will take to source some of my thoughts from, that Miemie and I will share with you today. So what we wanted to do was to share with you some of our research that we did a while ago, which started out by looking at sustainability more generally, but we then went more deeper and to particularly look at what kind of mechanisms and opportunities would there be to incorporate sustainability into consumer protection policy. So we wanted to share the findings very broadly with you, but also use that to share ideas and what we hope might be some aspirations that we can work together on jointly around incorporating sustainability into consumer protection policy. So if we can just start with what we probably already know, which is that there's sustainability as a public policy domain and there's consumer protection as a policy domain, but there are many overlaps and overlays between these two areas of policy, which are quite similar actually, and which I'm sure you are familiar with. I mean, what we know is that both of them are not really one-dimensional. They're very multifaceted, they cross many domains, they're very interrelational, interconnected. They are about people, planet, and prosperity. That's sometimes used in the sustainability rubric. And in consumer protection, there's always talk about the economic, the social, and the environment. There's also, there has to be confluence if sustainability policy is going to be coherent and impactful. And similarly with consumer protection policy, there has to be convergence across all the different domains where consumer activity takes place. So there needs to be integrative mechanisms, and that would be both horizontally and vertically in this area of this domain of public policy. And for impactfulness, particularly with consumer protection, and we find this in the tribunal, there has to be coordination across different departments, whether they are linear or whether they are at different levels of government. There has to be that coordination if it's going to be impactful. Now, in terms of what the sustainability policy and consumer protection policy are aiming at and wanting to achieve, we see that there's a bit of similarity once again, because with sustainability policy, it's really about balancing the needs of current and future generations, whereas consumer policy is about balancing the responsibilities of businesses and consumers and where they meet. But both of them actually have resources at their core in terms of what they have to manage. So that suggests, in terms of the intersection of the policy purpose of sustainability and consumer protection, that they both share an intentionality to change consumer and consumption patterns. Both of them intersect around the desire for a better quality of life and a fairer and safer world. And also, if there's a way to incorporate sustainability into consumer protection policy, our research was believing that this can magnify and positively impact on achieving sustainability. But the trick, of course, is to get it right, to incorporate the policy, the sustainability into consumer protection policy. So zooming in a bit on consumer protection policy itself, I think that...
Catch that. Could you try again?
Sorry about that. With consumer protection policy, we know that it is not able to regulate the extent of consumption. So you can have the best policy, but it doesn't necessarily limit the amount that a consumer will actually consume. Provided they have the means to purchase, they can continue to consume to any amount. But what it does have the ability to do is to regulate the choice of consumption, because the regulations can set out ways in which the type of goods that's available and that are accessible to consumers is regulated and limited. So that brings in quite a powerful lever of change around consumer choice. Now, we all know that consumer policy runs along the spectrum that I think the Commissioner was speaking about when he spoke about it being able to be mandatory on the one hand, but also voluntary on the other hand. It can also be about persuading rather than insisting and enforcing. So it's really a mixed bag of tools that can make behavior change happen along a spectrum. So we have so many tools in consumer protection policy, but the trick is whether they can be used effectively to impact on sustainability as well. So we would argue that consumer protection policy runs along spectrums. It's about, on the one hand, having what's sometimes called the kick, the compliance kick, towards the hug, which is more the persuasion dimension. It also can be formal mechanisms which are in law, but it can also be informal and less formal if there's regulation of sectors themselves. And in the African context in particular, the informal sector as a whole is quite interesting from a regulatory point of view, because how effective is policy in general when your market is quite informal? But again, if we get it right, we can influence sustainability choices by using the full spectrum from making it mandatory through to self-management. And I must say that at the National Consumer Tribunal, we find this quite a lot in the work that we adjudicate on. We find that parties, of course, are welcome at any point to meet and to come to agreement on arrangements to settle their disputes. But what tends to happen is that until the regulator actually brings a case as an application to the tribunal, the parties still don't come and get to settlement. And it's only with that the sword of regulation and mandatory implications hanging over the respondent that we find that they often move towards settlement. And that can even be on the day of adjudication. So that, I think, supports the fact that even though one might not want to see too much of heavy-handedness in policy, it does seem that we need those compulsory tools that can insist on compliance in order to drive parties towards voluntary compliance as well, and through that to impact on behavior and to impact on possible sustainability choices. So, Chair, if I could then move to our actual research, we tried to develop a bit of a model to guide looking at finding ways to incorporate sustainability into consumer protection. And we had different levers that we were testing. The first one was about a definition of sustainability in policy itself. The second is to adopt a life cycle product life cycle approach. Could that be a mechanism? Then what about self-regulation of a sector, be it fast-moving consumer goods, be it auto sector, any sector, is self-regulation something that can work to drive the inclusion of sustainability? And then what type of policy instruments were countries already experimenting with, or had they put into their policies to try and achieve better sustainability? What was also great about the research is that we found with the countries that responded that there were quite novel policy innovations that I wanted to speak a bit about as well. So we were quite glad that most of the countries that responded were African countries. And that's because we have been trying to build a network of consumer protection agencies across the continent to try to be more impactful on regional policy on the African continent. I'm sure colleagues will know that the Africa Free Trade Agreement has recently been signed, and so that's an opportunity for consumer protection, but only if there's impactful lobbying into that space. So some of the countries, if we feel if we can come together, we can be that stronger voice and then influence regional policy. So with consumer protection policy in Egypt, I won't go through all the details of every country, but just to say that what we found great was that sustainable development is actually a constitutional provision in Egypt's constitution. But the possible disappointment is that it does not cascade through into a clear policy provision in consumer protection policy itself. It does, they do have some instruments which could be helpful. They do regulate that consumers must be provided with information, and again, we heard the Commissioner speaking about that. What was helpful and a possible way to be more effective, we thought, was that the Consumer Protection Agency, which is very active in Egypt, does have responsibility for the ongoing development of consumer rights. And could they deploy that responsibility by pushing into the sustainability domain? That would be the question. Then with Botswana, their consumer protection law was under review when they responded. So some of their policy was perhaps not as far-reaching as their new policy will be. They do have very specific regulations around biodegradable packaging. They also have a very active consumer protection agency. And their definition of unfair business practice is very broad, and I think is, again, where potential lies, because it states that there's a compulsion that businesses must do all things as may be necessary to protect consumers from being otherwise exploited. Now, I'll get to it a bit later about what does things like broad definitions like otherwise exploited mean, and how can that be used to drive sustainability. The next country was Zambia. Zambia has some elements of sustainability because they talk about product labeling around ingredients. So there you can track whether your ingredients are from sustainable sources or not. And they have mandatory product information. Also a very strong consumer protection agency, and it's established to enhance the welfare of consumers. Again, a broad term, what's the potential there in relation to sustainability? They also have the notion of unfair trading. What was very important to note from Zambia is that they had started to consider policy regulation for the informal sector, particularly with roadside trading. And again, for the African economies, that's very important because, as colleagues will know, a lot of our economies are informal. And so how do we regulate into those economies and start to deal with sustainability there? One of the reasons they started to look into roadside trading was because there were solar products being sold by roadside businesses, and it was quite new, and there was quite a lot of complaints about them. So with the introduction of more sustainable products came some consumer issues, and that gave rise to thinking about policy for the informal sector. I think that's the space that we need to watch. The next country was Mauritius. They have some elements of sustainability defined in their law, where they talk about a consumer market which must be sustainable for the benefit of consumers. So that's something to build on. And then they have quite a lot of regulations which begin to deal with the whole of the product life cycle from production, but not necessarily all the way through to disposal. But they do touch on some of the elements within the life cycle of a product. And they have a lot of policy instruments around safety standards. Then Tanzania, their policy instruments talk about unfair and misleading market conduct, and they have a lot about product safety, but stuck in what I would call the old mode of product safety, and not necessarily a very broad definition of products being safe from an environmental and a sustainability point of view. They also deal with the product life cycle by product information standards regulations and the need to disclose, particularly the performance of a product, its composition, and its content. And then I think, again, I'll come back to this later, they have the term unconscionable conduct, which is prohibited. I think if we get to the definition of that, there could be huge scope for regarding unsustainable practices as unconscionable. We then looked at some what might be called more economically developed countries. The one which responded was New Zealand. A very comprehensive consumer protection regime in New Zealand, which quite incorporates sustainability with consumer protection, and notes that they both need to be promoted simultaneously if they're both going to be achieved. And they have good policy for the whole of the product life cycle. They're very strong on voluntary codes of practice, which is a soft law, if you like. And they have policy instruments which support honest business and reputable suppliers. Again, we can come back to that. What does it mean to be honest if in relation to sustainability claims? And they are very principles-based in their consumer law, which I think gives a lot of scope for referring to international instruments that one can then leverage as principles to be applied in consumer law and consumer protection. The other country which responded was Sweden, and I think it's a really helpful example of very comprehensive and inclusive policy. It grounds its approach in social equity, looking at development and equality. It has the principle that goods and services should not harm consumers. Again, I think that's a powerful term in relation to sustainability. And its policy is based on the notion of think twice and drills right down to household consumption level about how consumers should try to achieve eating, living, and traveling more sustainably. And I think going down to the household level for consumption is a very powerful way to begin to drive behavior change in consumers, which is where some of the power lies to achieve more sustainability. Of course, we had to look at our own law in South Africa, and there are allowances in policy for sector self-regulation, and we found that the wine industry in South Africa has actually gone very far in terms of self-regulation around sustainability, and particularly right from the production of the natural ingredients to certification and product information about sustainability. So that was a very helpful case study, because sector self-regulation, as we know, can either work or not work at all. It can be too weak, it can be too soft and too self-serving. I think, Alessio, you were almost referring to that in some of the law that you were sharing with us. We also have the notion of prohibited conduct in our law in South Africa, but it's only conduct that's specified in the Act that can be prohibited. And if the Act doesn't go far enough, which I don't believe our legislation does, in relation to sustainability, the prohibited conduct has a potentially limited impact on how it can drive us towards sustainability. But we can change that in terms of how we draft new additions to the law. Particularly perhaps because of our history in South Africa, we have a lot of concern for vulnerable consumers. And vulnerability is defined more in terms of need and access, but I think it's another notion to think about vulnerability in terms of the impact of global sustainability challenges. So then just as a bit of a summary for some of our findings, and leveraging off the four dimensions that we looked at, you'll recall we looked at a definition of sustainability in policy. What we found in our research is that whether or not sustainability is defined in consumer protection policy seems to depend a bit on the level of economic development of a country. It's more of a policy imperative in developed economies, and in the African countries that we looked at, it's not really defined in consumer protection policy. Again, that's then an area for possible policy reform. Then, if we go with the notion that we can incorporate sustainability by adopting a product life cycle approach and looking at policy from the raw material stage to the disposal stage, what did we find there? We believe that taking the household as the basic site of behavior change is very powerful and should be thought about more in terms of how one conceptualizes consumer protection policy. Also, as with in the New Zealand example, where they look a lot at the environmental impact and providing a lot of information to consumers about the environmental impact of each product, that is very powerful for enabling consumer choice. And consumer choice is another very powerful way in which policy can drive sustainability. Then, in terms of the elements in the policy itself, for each stage of the product life cycle, we found that there were only elements and nothing comprehensive in a lot of, particularly the African countries. And it was more at the point of sale where a consumer could come across information about environmental impacts or sustainability impacts, but at no other point really of the production and disposal of products. So it was quite limited. And for it to be impactful, I think there's a need for a complete wraparound, that all elements of the production life cycle need to be regulated for sustainability concerns. Then, in terms of policy instruments, I've been speaking as I've been going through about promising concepts that were in different policies. The notion of unconscionable conduct, prohibited conduct, consumer harm, consumer welfare, safe products. But I think we found that these promising concepts are quite hobbled and hamstrung in terms of impact, because if there's no sustainable policy imperative up front and embedded in the broader policy, although they might come across as seemingly unfettered terms, being able to interpret these concepts, these policy concepts, as applicable to sustainability is somewhat limited. And then the fourth element that we'd advocated for was sector self-regulation. And I think I've spoken a bit about that already within the South African instance. But what the research also found is that where there are active consumer protection agencies, they're doing a lot of work to educate consumers, but there seem to be limited uptake of their powers, and a lot of them do have powers in terms of their legislation, to actually issue regulations, guidelines, and definitions for different sectors to work from as a basis. And particularly, there would be absolute scope for consumer protection agencies to begin to define sustainability as a concept and a notion that sectors need to regulate, to self-regulate around. But we didn't find that anywhere, that there was that push and that imperative to include a definition of sustainability as a basis for sector self-regulatory policy tools. We also found that there was limited enforcement powers that sector regulators had. There were ombuds in some cases, but a lot of it was voluntary. And so while it might be a good thing for changing business behavior, whether one can, as a consumer, claim your full rights through sector self-regulatory bodies is perhaps limited if their work is only of a voluntary nature in terms of their regulatory mechanisms. So that's the research that we did, and we would love to refresh it because there have been some changes since we did it. What then does that show us, and what can we do? Because I think we're all here today to talk about the changes that need to be made, because we're not quite there yet in terms of having fully incorporated sustainability into consumer protection policy. Firstly, I think there are the basic elements that we would all be familiar with to trigger a readiness for policy change. And that we would need to do by the usual ways of creating awareness, so that consumers and businesses are ready to embrace policy, contribute to policy making, and to drive its implementation. So that means we need to do the proactive work of cultivating and multiplying stakeholders' interest in consumer protection policy as a whole, but also then what it means for sustainability. Very importantly, I think we have to activate consumer agency. We know that that's often how change comes about, is by voice, social voice being activated. We need to identify business leaders who can champion this. We obviously need to inject urgency into the need for integrating sustainability into consumer protection policy. We all know the urgency of the global predicament, so we need mechanisms for that. And very importantly, because of the kind of kick and hug, soft law to hard consequences, we need to raise the visibility of consequence. Both for individual businesses if they do not change their business practices, but also for consumers if they don't change their behavior, and how that has that spin-off consequence for the world as a whole. So those are basics, and I think we know how to do those, and they can trigger the change that we're looking for. But then I would like to call on us to be bold. And to move for a real global policy push to incorporate a definition of sustainability into consumer protection policy as a baseline. If we do that, that then will enable agencies to apply a sustainability lens to what I think are the very powerful but underutilized notions of unconscionable conduct, prohibitive conduct, consumer harm, and the welfare of consumers, and particularly safe products. A product safety regulation has been around for a long time, but it's never really been used, in my view, for saying that is a product safe if it harms the environment at any point in its life cycle. It doesn't go far enough the way we've used product safety before in the past, I don't think, in consumer protection legislation. It will take a bold move, I think, to actually join sustainability policy into and fuse it with consumer protection policy, but I think it's very necessary if we're going to be able to get the full impact of those types of concepts that already exist in consumer protection. I think we know that the United Nations guidelines on consumer protection raise the notion. They do join sustainable consumption, but it's not really there as an imperative that it must be foregrounded in consumer protection policy. And I think that's what we need to do as people in this field if we want to see a real impact. And then just a final thought, if I may. I think it's well recognized now that the nature of trade is completely global, and e-commerce is unbordered. It does not recognize the sovereignty of countries in terms of where consumers can transact at the moment. That means that what does that mean for consumers, though, when consumer protection law is still sovereign-based? It's still on a country basis. I believe that we would need to begin to change the adjudicatory platforms if we're going to be successful in giving consumers proper redress, and if we're going to really have a global push for the incorporation of sustainability into consumer protection policy. And for that, do we not need to consider an international consumer court where all issues can be brought by consumers irrespective of where they are located and irrespective of whom they are transacting with at any point in the product life cycle. So I think that that is where we wanted to leave it, and we would really like to invite comments and questions from colleagues if you think that it might be workable to go for the bold push of incorporating sustainability as a policy imperative from the get-go in consumer protection policy so that we have that global impact. Thank you very much.
Thank you very much, Laura. This was beyond interesting. I've had a hand up now from Professor Micklitz, who has, I think, wanted to pose a question, if I'm not wrong.
Yes. Laura, thank you very much. That was a wonderful survey on all the problems that we face. Let me ask you 2 questions out of many questions that I could raise. So the first one is it feasible really to redesign the language that we are using, or do we need a break? Yeah. So what you are proposing is take unconsciousness, yeah, or whatever term in law, and is it possible, let's say, to green these kind of concepts, or do we need to have a different, let's say, yeah, a new start, so to say, yeah? So it's more or less the debate about evolution or rupture, yeah? That's my first question. And the other one is, I'm German, Laura, yeah? And in German, we have a wonderful saying, paper is patient, yeah? Means, I don't know whether it exists in other languages too, but I think you understand what I mean. I know so many reports, commissions, papers on sustainability, yeah? And all what I can say, words, yeah? Words. And have you, in the survey that you started, where you looked into all the countries that you were mentioning, what I really found fascinating is, have you also asked about effectiveness? Have you also asked what's really happening? Yeah? Or is it, okay, I'm a lawyer, but nevertheless, a lawyer is also interested what the law means in practice. Thank you.
Shall I check if there are more questions, Lela, or can I start to give some thoughts? I think it's also, these are questions actually which are for all of us, I think.
Exactly,
Prof.
Not a problem, you can start, no
Yeah.
worries.
Yeah, no, thanks, Prof. Those are really the fundamentals, I think, that you are raising. I mean, how do you really get change? And the whole issue of evolution or rupture, a very good case study for me is actually the United Nations Guidelines on Consumer Protection. If you look at that as a case study, that's been evolution. And as a result, I think my own view is that it's quite a clumsy set of provisions that are there, and perhaps rupture would have been more effective. So I think that it's a question, though, of not throwing the baby out with the bathwater. If sometimes change is incremental, and it's easier to take stakeholders along if one has some continuity for them to work with. But if that's taking too long and if it's not happening, that's where I see the power of consumer agency to really be better mobilized. I think that it's always surprised me a bit that we haven't really had a global consumer movement. Even in countries which have a strong activist tradition, there's often not that much organized consumer agency. And I think that that's where the real power lies to push for those changes. So So I would go for a little bit of a combination to keep the good. I think there's some good notions like the unconscionable conduct, but I think it needs to rupture into freshness in terms of grounding it in sustainability. That's where we have to start afresh, because that's not there in consumer protection policy, I don't believe. So that's the freshness that we need to start with, to say, as a bottom line principle, we've got to incorporate sustainability from the get-go. And that I don't think we've done yet. So that's rupture. But some of the other things can continue to evolve within that rupture, I think, because some of the concepts are powerful.
Thank you very much, Laura. Professor, was that a satisfying answer? Do we have another question maybe from the floor?
I could certainly respond, and Laura, we could engage for the next hour, but I will not do that. Thank you.
Without a doubt. If we don't have any questions for the time being, then I would invite you, Professor, to start your presentation on e-commerce and sustainability in the notions on consumer protection to wrap up this first session. So please, Professor Micklitz, the floor is all yours.
Yeah, thank you very much, Leila, for inviting me. I really feel honored. I think it's a wonderful occasion, and to put consumer protection in the broader context. I listened to the commissioner carefully, and I listened to the other contributions, and let's say my feelings or my perceptions are more or less contained in the questions that I posed to Laura and that I ask myself. Yeah. So I am currently a professor at the European University Institute in Florence, and I have been working on consumer law, in particular on European consumer law, but also international consumer law for quite a while. So I think it's an advantage or a disadvantage that my academic career and the development of consumer law went on in tandem, so to say. That means when I'm looking on sustainability and consumer law, I'm also looking back into my own life, academic life, and into the last few years that really developed from, and the development the law took from the 1960s, 70s on in Europe and around the world. So let me start with a bit of background. I have a PowerPoint and I have an article, Leila, that I can send to you, but I'm struggling with these technicalities, so please forgive me that I will not have a PowerPoint, but I think it's should be clear without a PowerPoint.
If you wish, you can also send it to me and I share it. That's not a problem. But if you prefer without, that's also great. Okay?
I can send it. If it works, I have no problems.
Then just send it to me and I will upload it without any issues. Okay? Thank you.
Okay. I will do that. Just 1 second. I'm sorry for...
You're in no rush. Take your time. Maybe just in the meanwhile, while the professor is trying to send the email, I just wanted to have one comment on the previous discussion, basically. I think that our biggest challenge right now is really not creating new laws, but how to make the ones that exist function. There's a lot of law on books and not so much law in practice. And I think that would be a welcome topic for one of the next discussions or the next year edition of Incorporate Sustainability, to try to reason as to why this bridge from theory to practice has not happened yet or why it's so delayed. So I just wanted to add that I completely agree actually with the presenters that that's where the issue lies right now. Okay, I have it. Just 1 second, I will share it, and you can start, Professor, without a problem. Here we go.
Leila, I spent too many years of my life in an English-speaking environment. You can just call me Hans. That's fine.
Thank you very much. Okay, let's do it like this. Zoom doesn't want to minimize things when you are sharing. So when you are recording, it doesn't allow me to minimize it, but we will make it. We always do. Okay, let's do it like this, like this.
Okay.
You should be able to see it. Is that okay?
Yeah, could you just move to the first slide, please?
Of
Thank
course.
you. So let me start with, as a background, a bit of background music, yeah? We all know the sustainability goals. They were adopted in 2015. Laura mentioned them again, and we have here something on consumption and sustainability in the sustainability goals. And what I want to refer to is about the mismatch between a revision of the European consumer law in the last 5 years. That means under the last president of the European Commission, the idea was to modernize consumer law under the notion of refit. That was the heading, refit. And here, Leila, I have to disagree with you, because when you look into all these consumer laws, what I did, of the European Union, that are setting the benchmark for what the member states in the EU have to do, means they have to comply, and having in mind also the large impact that the EU legislation has as a source of inspiration far beyond the EU, what I studied extensively with a lot of colleagues around the world, it is amazing to see that these modernized consumer law contain more or less nothing about sustainability. There is some rhetoric, yeah, but there is no serious attempt in this modernized consumer law on e-commerce, on sales, on unfair commercial practices, on contract terms, whatever you want. No serious effort really to make an effort to either, in the meaning of Laura, to put impact on a transformation of the consumer policy goals towards sustainability, let alone an effort to clearly say, okay, our common broad concepts, legal concepts like unconscionability or like good faith or reasonableness have to include the big issue of consumer of sustainability. Nothing, yeah. So, and that is more or less a finding. What Laura confirmed to some extent. You may have sustainability at the level of the constitution in various countries. You may have all sorts of policy documents by the governments around the world, but you don't have clear-cut rules in the existing legal body of consumer law that really takes sustainability seriously. And we have a huge discussion now in the last 2 years that is blossoming, where lawyers, young academics are doing exactly what Laura proposed, which is one avenue. Evolution means to use the existing set of consumer law and to stretch it, yeah? To stretch the law and to argue, okay, if we take sustainability in, then we might have this and that result. And I'm simply wondering whether this is enough. And my intention is, in the time that is left, to give you a tiny little example in order to be concrete, in order to illustrate the regulatory gap and the need to think sustainability and law together, what is not yet the case. I would be very clear on this. So could we move on to the next one, please? So the research question is a simple one, and I think, and also it has been mentioned. In light of COVID, we have seen an enormous growth of the online business of e-commerce, and consumers more than ever around the world are using the internet to order their products. In the EU, there is a directive, I mention it here, on consumer rights. Details do not matter. But what is important is just one rule that we were focusing on. Yeah, I read it out. The consumer shall only bear the direct costs of returning the goods unless the trader has agreed to bear them, or the trader failed to inform the consumer that the consumer has to bear them. So what happened in practice is that for competition reasons, most of the online business decided to take over the costs for the return of products that consumers are ordering. And we have tested the potential in the case of Germany. I will only give you some figures that illustrate the dimension. Could we go on, please? So here you have the return rates for Germany in 2018. There is a little institute at the University of Bamberg in southern Germany that is dealing with these statistics, and they are quite telling. So we were focusing on two groups in particular. Why textiles and consumer electronics, so small consumer electronics, because these are the two types of products that are ranked on top when it comes to return. Yeah, so I think the phenomenon is well known, but the textiles are ordered in different sizes and different colors, and then consumers decide what they want and they send the rest back. So here you have some figures. The total costs in Germany are, for Germany alone are more than 5 billion in 2018. 80% do not charge fees, as I told you, and we have 20 million returned items, so that are simply thrown away. So 4% of the overall return. Could we have the next one, please? So now let us change perspective. In these days, we are talking a lot about global value chains. And that is a well-known phenomenon, also some 10 years old at the minimum. In the economic literature, there's quite a move to discuss how these global value chains were made possible, in particular to the reduction of communication costs and the internet. That was the major focus to build these global value chains that allowed the producers or companies to organize the production, the transport, the raw material, the distribution, the after-sales management, anything as a kind of upstream or downstream chain of supply. That has global value chains have raised a lot of concern in various fields of the markets. Take energy as an example, or take timber, or I think we are all aware of the various policy initiatives that have been taken around the world to handle global value chains. And we are also aware of recent efforts to regulate global value change. That is an amazing development we have countries around the world that are adopting laws. France was at the forefront. Now we have others. Also, Germany has adopted a law, and the European Union is discussing to regulate value chains. We will see what comes up. And I want, no, please, I would like to demonstrate one thing here in the debate on e-commerce. When you look at consumer law, yeah, all what you have is just a tiny little bit within the global value chain. Yeah, it's very hard for the consumer to know something about the raw material, to understand the production and where it takes place and under what conditions, to know about transport, and then once the consumer has bought the product and returned the product, we may have rules on after-sales management, recycling, waste disposal, but that is not regarded as consumer law. Yeah? So consumer law is just covering the buying and paying, yeah? Whereas it is very important to look into the various stages of the global value chains and to link them to the point of sale, means when the consumer takes a decision. And in the paper, I can send it to you if you want, we have analyzed with regard to the two products, textiles and consumer electronics, we have looked into backwards and forwards, upstream and downstream, into the various set of rules. Yeah? So what kind of rules exist from a consumer point of view on the raw material? What kind of rules exist on getting to know where and under what conditions the production takes place, and the transport, and the distribution within the EU once they arrived at the custom borders and the containers are opened. And then downstream, possible reselling of used products, recycling, and waste disposal. And the message that we can convey is we have a mixture of binding national law, we have binding European law, then we have international law, and let me spend a few words on this in order to illustrate the dimension. The economic order, until today, at least, we can, for the moment, we can agree to this, is still governed by WTO. Yeah? So by the rules on that govern the trade and services of products around the world. And here it comes. The international economic order is only looking at how the products are traveling around Europe. But the WTO, the International Economic Order, is not allowing to look into the production process. So this is left for the economies of scale. This is left for let's say, the countries where the products that are shipped to Europe and the US are produced to compete via low standards, low labor standards, underpaid workers, and disastrous environmental protection rules. That is outside the scope of the WTO. This is linked to various UN laws and organizations, but the two, the World Trade Order and these sustainability elements, they are not linked. So that is a big barrier for the law. So to be very concrete here, one might even raise the question, and it has been discussed, to what extent it would be possible for one of the countries that Laura mentioned to introduce a ruling saying and informing the consumer on where the product has been produced and under what conditions. And that seems to be the direction where the EU is moving if we look at what the Commissioner was saying. However, it is not at all sure whether this is in line with the international trade order. So, okay, maybe then we move on. So what are the possible solutions? I think we have to take a holistic perspective. That means if we take e-commerce and the e-commerce trade, we have to broaden perspective. It does not suffice if we take sustainability seriously just to focus on e-commerce trade, on return rates, right to withdrawal, and whatever niceties might there exist for consumers. But we have to look into the whole chain of supply and reallocate responsibilities between the state, business, but also to consumers. We have to raise the tricky question to what extent also consumers have a responsibility, and not only a right to choose, but also a responsibility for the environment. I wrote a paper on that we have to rethink consumer law from scratch. You may know this wonderful book from Frank Trentman, who deals with the history of consumption, the empire of things, and where he looks back into the last 500 years, going back to Florence and to the Renaissance, where, according to him as an historian, it all started with the consumption. So we have to rethink our understanding of consumption as something which is unconnected to the environment and the consequences. And that might require a new way to look at consumer law, and it might also require to look at other means, like what is the economic contributions of producers for the cost of recycling. How can we reduce the raw material? Can it be taxed? And so on and so on. So there is a lot to do, and here I disagree with all those who say maybe our laws are enough. Maybe we have enough laws. Yes, I agree. But the laws are not connected. They are not at all connected. Each of the laws is regulating just a particular piece, and they remain unconnected and not interrelated. Thank you very much.
Thank you very, very much, Professor. No, I'm in absolute agreement. That's why this event exists. It's about policy coherence for sustainability, right? And my complaint before was that we're just kind of having these separate laws. There are many and plenty, while in practice, the actions don't change much, right? Because they're kind of informed by all the diverse rules that are not interconnected and they're not very clear at this moment. But it's welcome that we're changing, basically, the legal environment enough to be able to envisage new solutions. Thank you very much for a very interesting presentation. I think I could go on and ask you 7 million questions right now in general, but let's leave the floor to our participants. Do we have any questions, comments, doubts that you would like? I see Alessio, you can go.
Thank you very much, and thank you very much to Professor Micklitz for his presentation. I agree very much on what Professor Micklitz was saying regarding the fact that we don't have a comprehensive regulation on that. The problem is that sustainability is more an attitude to be pursued than simply a series of legal provisions to be put together in order to make it work. And basically, we have an even backwards question, that is what sustainability actually is, because this is a key issue. Nowadays, in my perception, sustainability is used by the companies, by the firms, basically for greenwashing.
basically for greenwashing. Not in all cases, but the cases in which this has been made for a rather opportunistic behavior, it's, well, they are, in my perception, the majority. And in any case, I found the example that Professor Micklitz pointed out very, very interesting, because they are making us very clear that sustainability should be also linked to market, because naturally that attitude of the free returning goods is a market-driven attitude. It's something that is made to get more customers as possible. And this is actually what any company in the world would do. So the problem is how to regulate in a sustainable way, if it is possible, this possibility for returning, if we want to give this possibility.
I have a proposal to this, Alessio. How we can do it. I have a proposal. I think we all have learned a new word that is being promoted by the European Commission, sandboxes. Yeah? So sandboxes as to test and experiment with new approaches, mainly in technology, finance, whatever, and to create a kind of privileged legal space, yeah, for experiments. And my proposal is the following. There are good examples, yeah? So there are companies who, on a voluntary basis, in the textile sector, to be very concrete, are trying to take sustainability seriously, yeah? So they they are looking into the chain from the beginning to the end. They're exactly doing what I'm claiming. And what I propose is to bring together, to use these positive examples and to bring together economists and lawyers, sociologists, computer engineers, whatever, and to try to build out of these positive examples a legal framework. Yeah? To use them as an example and then see, okay, how can we, what these good companies are doing, how could we translate this into a legal concept? Yeah? By way of a sandbox. Not, avoiding these huge discussions in parliament and blah, 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 yeah? But just do something, yeah? And find out whether it works, and then proceed from a ground level to a higher level. That's my proposal. Yeah? Because we have enough paper, I'm sorry. Yeah?
Thank you very much, Professor.
Thank you very much.
Alessio, was that a good answer? You want to rebut
No,
on that?
of course it was. Of course it is, because it is, it is driven on their needs. From
Exactly.
The
Exactly.
If you are listening to them. Basically, this is something that should be included also in the legislative proposals of the European Union when they listen to stakeholders and so on and so forth.
Exactly.
But not always it is actually effective.
That's another story, but...
Exactly. Exactly. If we don't have any additional questions, then I will let you all go and have a nice break, because these screens are a lot. We will be reconvening in 30 minutes at 12:15 for the second session on consumer protection and sustainability, and I'm looking forward to seeing you in 30 minutes. So a short break, and we'll be right back. Thank you, everyone.